Hello everyone, Tanse Nitotamak. My name is Vaughn. I'll be your moderator for today. And before we begin, I'd like to start with a land acknowledgement. The University of Alberta respectfully acknowledges that we are located on Treaty 6 territory and Métis Nation Zone 4, a traditional gathering place for the diverse Indigenous peoples, including the Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteau, Anishinaabe, Inuit, and many others whose histories, languages, cultures continue to influence our vibrant community. I am here speaking to you today from Miskouchewaskahagan, colonially known as Edmonton, here in Treaty 6 territory. I am here today from Treaty 8, and I would like to extend my thanks to all the nations that make my presence here possible. I would like to encourage all listeners to today's talk to reflect and acknowledge on whose land you're on. The talk today is part of the Sustainability Council lecture series. During the academic year, the Council hosts interdisciplinary scholars, professionals, and activists who engage with sustainability, climate change, and the environment. The lectures are usually bi-weekly throughout the academic year. Just a note, for the benefit for those who could not be here with us today, we are recording this lecture and we will publish it on our YouTube channel in a few weeks. The audience will not appear in the published video. Now, it is my great pleasure to introduce to you our speaker for today. Professor Val Napoleon is the acting dean of the Faculty of Law at the University of Victoria and the Law Foundation Chair of Indigenous Justice and Governance. She is the co-founder of the JID-JD, a dual degree program in Indigenous Legal Orders and Canadian Common Law, and the founding director of Indigenous Law of the Indigenous Law Research Unit. She is Cree from Saulteau First Nations and an adopted member of the Gitanyow, the Northern Gitxsan. Val Napoleon, welcome.
I'm so glad to be here. Thank you for that introduction. I'm joining you from the lands of the historic and present day lands of the Lekwungen speaking people on southern Vancouver Island, and they have more lands than that, and specifically the communities of Songhees, Wasonic, and Esquimalt. So I'm delighted to be here, and I'm looking forward to your questions. I have a PowerPoint which I'm going to share. I was told a long time ago that people listen better if they have something to look at. So that's part of the reason for the PowerPoint. I also hope that you'll appreciate some of the images that are contained in it. So here we go. So my way into the topic of sustainability and Indigenous law is through one of our projects, a graphic narrative that I'm really, really proud of. It's not yet public, but it will be soon. There's some final checking that has to go on with spelling and so on. So this, the story for this graphic narrative is myself and two colleagues, Sarah Morales, Deb Curran, and they are colleagues here at the law school, and Sarah in particular is from Cowichan tribes, just a little bit north of here. So part of wanting to show parts of this graphic narrative to you is just to present another way of engaging with complex issues that matter to all of us in ways beyond the academic paper and in ways that can go beyond the university. And so this is our second graphic narrative, and I'll tell a little bit more about the other one as we go along. So there have to be many, many ways for us to, all of us, to generate the kinds of conversations that we need to engage people in all of what matters to them and the various issues which are affecting their lives, their families, their communities, and so on. So this is one way, along with numerous other ways to generate that kind of engagement. So this story, if I can figure out a way to change the slide. Oh dear. Okay. Let's see. Sorry. Okay. So this story, it brings together origin stories, it brings together issues, it brings together different oral histories, and the first part of it that you see here is Sayalutsa, and she was, or in the original story, it was a male. He was the first human being to descend to Coxella Ridge by Cowichan. And we've changed the gender so that we have both male and female energies. And I know that the world is not heterosexual, that there are many other ways that people have of being in the world. And then Sayalutsa's brother, Gitxsan, was the second human being to arrive. And so these are characters which take up a story as teachers, as people who talk to the other characters in the story. They're a really important part of Halkomenum law. They are part of how people are connected to those lands and to those waters. And so they are drawn and introduced into this graphic narrative. We also have Una and Milo. They're two children. The intention here is that they are ordinary children that other young people and kids can identify with. And it's through the eyes and the actions of these children that the different oral histories and origin stories are drawn upon in order to be able to address the concerns that the kids have about their river, the Cowichan River, which is in trouble insofar as demands being made on it, as insofar as flow of water, insofar as salmon, insofar as the health, insofar as all of those different kinds of issues. So Una and Milo are the characters that tell a complex story, but in a way that will enable people to see themselves in the story. The other narratives that we draw on, one is Ladybug. She's one of my favorites. She saves the people from a flood by drinking up all of the water. And there's a song about her that can be sung in order to call on her to come and help. Again, you saw her in the previous slide. She has kind of an alter ego, Water Woman. And Water Woman is she takes the role of a teacher here in the story, and she ties together different aspects of the story in a way that can be presented and told. And I understand from Sarah and others that water, has its own spirit, and so I also look at Water Woman as representing that spirit of water. Thunderbird and the Killer Whale. This is a fantastic narrative about a rogue killer whale which blocks the Cowichan River and eats all of the salmon and refuses to share the salmon. So there's this big epic conflict regarding the fish, the water, the obligations that people have to one another. And what the people do is they call on all the other villages to come and help, and they all raise their voices to Thunderbird, and they call on Thunderbird to come and help them, and they pray for that help. So Thunderbird comes, and there's this incredible battle. It's described as shaking the earth and churning the ocean, and it's a battle to the death. And Thunderbird wins. And so you can see Thunderbird flying off with the killer whale. And the idea is that there are many ideas, but one of them is that you can continue to call on Thunderbird, and we can look at these different elements of the stories. We can understand them as catalysts. We can understand them, as as ways of thinking about today's issues, because people dealt with complex conflicts in the past, and those tools are available to people today. So there are many challenges. I mentioned earlier that, the Cowichan River has many demands being made of it by, increasing urban centers, and so on. And so there's learning to draw the law from the different oral histories, learning to look at the principles, learning to look at how do they apply today. All of that is the work of Indigenous law. And one of my favorite thoughts is that law can be understood as an intergenerational conversation, that it can be, it's the job of every generation to draw the wisdom from the past, to draw on the precedents of the past, to draw the lessons and to bring them forward to solve the problems before them. So law is always living, and it always lives through the stories. When we think about the common law, we know that it's told through stories too, different kinds of stories told in particular ways, but it's stories, it's ways for us to understand situations, issues, problems, things that we have to deal with. And so that's part of working with Indigenous law as well as other systems of law. We have, bringing the law forward, the legal principles forward, is into legal practice today. And legal practice today is to deal with the challenges of today, which are different from those that were challenges in the past. And there's pedagogies, there's all different pedagogies about ways of teaching. There's no one right way to do that. This graphic narrative is one way, but there are other ways that, in classrooms or on the land is one of the classrooms. And this deep engagement with law, one way to understand it and to think about it is as democratizing law, as making sure that law, which is everybody's business and affects everybody, Indigenous law and non-Indigenous law, that there's a way in for people, that they can see themselves in the stories and in action. That's really important. The other point, just before I leave this slide, is that one of the biggest challenges for legal pedagogies today is that, Indigenous law, as with other systems of law, if they're going to live and be effective, we have to be able to create meaning with it. We have to be able to internalize it. And, when we think about Canada or any other country or peoples, law in Canada doesn't exist just because there are rules. It exists because people understand the law to exist and therefore enable it to exist. And so when we think about that internalization, that internal view of law, we have to think about that insofar as pedagogy as well. I love this picture. It shows the kids engaging with all of the different aspects of what's going on with the river. So they're live, it's complex. It's not dumbing down any important conversations, but it's done in a way that these kids are having the conversations. So it's creating ways into more conversations. It's also creating new narratives and new stories. And part of what will accompany this graphic narrative, as well as our other graphic narrative, is teaching guides, so that then people can use them in lots of different situations. And that's an important part of the graphic narrative. So the kinds of issues, live complex issues, they include water licenses. They include who makes decisions over water licenses. urban demands, competing interests in water, logging, pollution, pesticides, agriculture. So all of the different kinds of real situations that have been created around this river and which are impacting this river so heavily, these are part of the conversation in the graphic narrative. And so what you see here are the kids drawing and setting out what some of those issues are. And then, because it's really important that we don't paralyze people, we also include lots of conversations about how people are working now, how they might work in the future. So the Gitxsan is, it does all kinds of really important work insofar as co-management. And so there's looking at continuing water governance. There's looking at flows and at balancing competing needs for water. And there's all of the issues regarding what is sustainable and looking at what that sustainable means for continuing life of shellfish as well as fish. There's the changes which have been made in so far as agriculture. There's continuing changes that are necessary insofar as sewage. There's ongoing work that kids can do as water warriors, and and others can do as well, and do insofar as water samples and so on. There's continuing public legal education and environmental education, and there's finding opportunities for those educational activities with the different systems of governance around us, and always drawing on Indigenous law as a reality in the world, as a way of thinking, as a resource to tackle the kinds of problems that people are having today. This is not to idealize it. Law doesn't provide the answers. It enables people to figure out what the answers are to the problems that are before them. We all need repertoires of success. We need stories where we can see ourselves in those stories. So that we can see ourselves as solving problems without conflict. And that is that's an imagination that we create through the stories and the narratives that we tell. Some of the writing of Charles Taylor speaks to that, for instance, but lots of others have talked about the importance of creating the world through the narratives that we tell. One of the people whose work I've drawn on has written about how we actually operate in the worlds that we believe exist. So what is it that we believe, and how do we expand that or inform that? The big lesson for Una and Milo in this narrative is that they realize they have to stop waiting for others to move first. And that's so central, so fundamental for all of us as agents in our own lives, as legal agents, according to the laws that we have. So Nutsumet and our other projects, their research, a lot of the background work that's done is in partnership for research projects with different Indigenous peoples in different places, much like the Wahkohtowin Law and Governance Center at the University of Alberta, and two other centers that are now in Canada, in North Bay and in Windsor. So there's Indigenous and peoples and allies who are working to substantively articulate law and legal processes around different subject areas and around different questions. And so we've had 4 water projects that we've been doing here: the Tsilhqot'in, the Cowichan, Lower Similkameen, and more recently the Nicola. And these projects are all in regions where water has been a challenge, where there's a scarcity. Nicola, for instance, one of the big issues that people there have talked about is how this last summer, with the terrible heat that was experienced everywhere, there and the lack of rain, combined all of those things with the fires, meant that people were in the position of having to choose what to do with water. Do you put the fires out, or do you keep enough water so that the fish, the particular kind of freshwater fish that they have, can survive? And so those are terrible, terrible situations that people are in, and they're real. And there needs to be ways for people to come through and manage what they can through those situations. So they're resources. The idea is that these are all resources that people can use for the work that they're doing. This project was funded, a lot of it was funded by SSHRC and by the Real Estate Foundation of British Columbia, and was a project between our Indigenous Law Research Unit here at the University Faculty of Law, and also our Environmental Law Center, which is a part of the law school as well. So there's, I think, you know, this is one aspect of our work, and others are doing, you know, other things. There's much more that can be done in terms of important research, collaborations, implementation of the kinds of Indigenous law reports that people are compiling. There's so much in the way of richness and resources that are there. Micamosis, this was our first graphic narrative, and a week ago we drew on the brilliant work of Dr. Hadley Friedland, who's at the Alberta Faculty of Law, in order to prepare this graphic narrative. So this is used and has been used for since 2000 and I'm not sure when now, quite a long time. And it's used everywhere. You know, and it's used across disciplines, which I find really interesting. So it's, you know, it takes up questions of Cree criminal law. It takes up questions of law conflicting between legal orders. It raises questions of mental health and gender and violence. And it does all of that with Cree legal references, so that there's many, many touch points and perspectives that tell a different story here than what we know that colonial history can tell. We now have, there's been so much demand for this and other work that it's been translated. We're looking at publication, and we're also going to be making a French version available online, and then people can download and have that as well. So all of our resources are available online, and that website's been put in the chat. There's the pro bono students here did a video with Micamosis, and so that's also a great kind of thing that students can do with the resources that are created. This slide I show just because it's Indigenous Law 101. It's like a little capsule of what can either be a 1-month intensive course, which we teach, or a full term course, which is going to be taught here in January, or it can be a 3-day workshop. And you know, the resources here, again, the methodology, we draw heavily on the work of Dr. Friedland. We also draw on the work of John Burroughs. And so, you know, it covers some of what I've said, that, you know, if we're going to work with Indigenous law, we really have to challenge how we think about what law is. We really have to understand that it's a human endeavor, a human creation. and that it's a distinct part of governance. Like we have to rethink the big ideas that we have about law. There's a systematic and critical methodology for drawing on oral histories and narratives in order to produce something that's critical and open-ended enough that it can be applicable to different problems. There's ways of thinking about authorities. Here they're called sources. This is drawing on mainly John Burroughs' work, because we don't have libraries that are full of texts, right? So where are our texts? Our texts are the songs, the resources here. They're the not, the elders or the art, the images, the expressions, societal expressions. There's memories, there's language, there's practices, there's all the different ways that law is recorded in relationships and in the different ways that people conduct business, whether it's obtaining a pole to carve for for a chief in the Northwest, or if it's another kind of work that's being done. So there are all of those resources. The ways that people have been applying the work and the projects that have been completed include environmental assessments, and most recently, one of the groups used the Indigenous Law Report to draft an impact benefit agreement. So they drew on the legal research, Indigenous legal research, and then they also tied that in with UNDRIP, or in BC, we have the provincial application called DRIPA. So there was, you can see how people are moving ahead. The kinds of resource or research projects rather that we have, there's lands and waters, as I've mentioned, but there's also governance, and there's human rights. So how do people understand human rights from an internal Indigenous legal perspective, concepts of dignity, gender issues, sexualized violence, and all of that. So there's all, like, human beings. We have, we're really messy when we live together in large groups, and we need to manage ourselves. And this is a resource to be able to do that in the past and for today as well. This is another of my favorite pictures. I find it really helpful to use it and have people think about, a number of concepts in like, how do we expand how we see things in the world? And this is a very old picture, several hundred years old, and there's no author for it. But, like the terms of reference that we create and that we have can actually limit us from seeing beyond our own terms of reference. And so when we're thinking about a legal terms of reference, which law, which legal order? Because if we think that Canadian law is the only thing that exists, we're not going to be able to see Indigenous law in the world and see how it is absolutely essential to Indigenous being a people, Indigenous peoples being peoples rather, and to taking on obligations that we have to one another. It's also, I think, a wonderful way to visualize Boaventure de Souza Santos' work on abyssal thinking, where our ways of seeing the world end at some point, right? In terms of our imagination and what we think about. And so what exists beyond that? And if we've structured the way that we think so that it closes out other ways of understanding the world and people and everything else, then we've created a situation where our thinking simply drops off into an abyss. And this picture represents that. There's also Isabel Altamirano, another U of A Indigenous scholar, who has written about grids of intelligibility. And so the challenge for us when it comes to the environment, when it comes to climate change, when it comes to what the economy is, and how the challenge for us is to think about what are our own grids, our understanding of the world, what do they enable us to see, what do they render intelligible, and what is beyond what we think is intelligible, and then to challenge that and to find, to expand or shake up our own grids of intelligibility. So I love the image for that. And I want to make sure there's time for questions. And so here's some information just on our research unit here. But as I've mentioned, you've got amazing resources in Alberta as well. And so these are the ILRU site is in the chat. And with that, I really, really look forward to your questions. And I'm going to stop sharing. There we go.
Yes, so as a reminder to everyone, please put your questions in the chat and we will make sure that they get passed along.
Great, thank you, Dr. Napoleon. That was really interesting to see. The first question is coming from Mark, and the question is, in regard to Dr. Friedland, have you read her book, The Week to Go Legal Principles, and if so, what did you think of it? Thank you for having me.
That's such a good question. So Dr. Friedland, I had the good fortune of having her as a graduate student when she wrote her dissertation and her master's, which was the early version, but her master's was the turned into the Week to Go legal principles. So I think it's a particularly brilliant way of again, drawing on the past to deal with the actual real challenges of the present. So what's fantastic about it is that it's not rhetoric, it's actual tools that can be applied to the kinds of experiences that people have. And the actual, and being real about those experiences. There's nothing worse than not being able to see yourself in anything around you. And one of the what's powerful about that is that it enables people to see and think and talk about sexual abuse, about our capacity to cause harm, as well as our capacity to love. So, and there's obviously much more to the book than that, but I'm a fan. I think it's really, really smart and really, really important.
Thank you. I'm going to ask a question, if you don't mind. So as I understand it, this I don't want to call it a book, but these graphics that you shared with us are, I guess, focused more towards like younger people, children, I assume. So my question is, how do you sort of articulate that these laws are laws to them,
Okay.
if that makes sense?
Yeah, thanks. So the mycomosis is actually taught in most Canadian law schools. So here, for instance, every law student that comes in, all 115 or whatever, or 100, actually more than that, 145 or whatever, they all work with mycomosis. And what they do is they learn how to do a legal analysis with that graphic narrative. It's the first lesson they have when they come to the law school. What we found is that if we have the students talk about Indigenous law when they first come to the law school, and the mycomosis is the way that we use to do that, then it becomes the terms of reference for other law that's introduced, Canadian constitutional law and so on. Whereas if we start with Canadian constitutional law, then it becomes the terms of reference. And so it's so interesting, like how that makes a difference. And so the the issues in Mikomosis, I mean, it's a graphic narrative, but the issues that it talks about are colonial history, are about a clash of, legal sensibilities, about the abuse of power, about all of those different things, and about it also includes how the legal processes through which people make really hard decisions regarding mental health, but which affect community safety. And so all of those are what students have to talk about, what they have to consider as they're going through and doing the case briefing and so on. So but kids read it too, and I guess that's the what I want to advocate as a tool. Academic papers are really important. All the other kinds of things that we create are really important, but if you can tell a complicated enough story in a way that can capture attention, in a way that to use Harold Cardinal's words, is elemental, not simple, but elemental. And I learned that from Tracy Lindbergh. Then you have a resource that can talk to lots and lots of people. So thank you for your question.
Thank you. Our next one is from S.E. Wasdell. Forgive me if I didn't pronounce you correctly. And their question is, what are some of the ways that Indigenous anthologies and epistemologies can be accurately represented in the courtroom without diminishing the integrity of these narratives by fitting into the colonial legal doctrine? Is there any case law specifically that you could point me towards where this was represented?
Yes. So if you look up some of the cases by Sébastien Gramond at the Federal Trial Court, then what you'll see is he, as an example, as someone who is drawing on Indigenous legal principles to reason through a legal response to a problem. So drawing on it not as fact, not as evidence, but as a way of thinking, a way to balance, a way to consider, and then to apply that to an actual problem that's before the court. So one of the things that I have told students sometimes is that, Indigenous law still exists in Canada. It's been undermined, it's been distorted, there's no pure, complete legal order that is going to leap to life with mere recognition. And there's no, it's not a thing, which is, a paper I co-wrote with Hadley Friedland. Some of the papers like take up that idea that it's thinking, like law is about thinking. It's not a thing that can be kept intact and protected. It needs to live by solving problems. And so sometimes I tell students that they're not important enough to break it. So I teach Gitxsan land and property law along with Canadian property law. And so students struggling with and learning and so on about that law, they're not going to hurt it any more than they're going to hurt Canadian law in the classroom. And so, I think that there are considerations that people need to make when they choose how they're going to go forward and what they're going to do with their legal orders. Going to court is one option to solve some problems at some times, but it's not the only way to engage with Indigenous law. And I think that there are going to be questions for how people represent themselves. Indigenous law is not just ceremony, it's not just philosophy, it's not just any one thing, it's a whole lot of things. And so, the maintenance of that complexity around the kinds of goals that people have and whether those goals can be met by litigation, that's what has to be thought through. So yeah, anyway, there you go, enough about that.
Thank you. Our next question comes from Kaylee. They write, thank you, Dr. Napoleon, for your time and wonderful presentation. I was wondering what your thoughts are on how Indigenous legal, intellectual, and legal resources might inform other quality of life frameworks, such as the Sustainable Development Goals.
Thank you. I think there's lots of ways that they need to be a part of the big conversations about what's happening to our planet and to sustainability goals. I think that there has to be more work done on how law in economies work, so Indigenous laws and Indigenous economies, and how might that those developments inform the kinds of economic decisions that are before us. Sometimes I see an assumption that the only possible economic order that we have is capitalism and that there's no way to change it. And that comes from our conditioning. It comes from, a pretty narrow political perspective of what is possible for human beings and economies. And so I think that there's more for us to do to conceptualize our own economies, our own citizenships, our own governance, and so on. So that's one level. Another level is, we can look at some of the work of the Haida as well as others, but Terry Lynn Williams Davidson, a long time ago now, talked about when she was a law student and she was involved with some litigation. Part of what she was successful in doing was writing in a way of understanding the environment, which included Haida women, so that there was a Haida woman in the low tide zone, there was a Haida woman in the cedar trees, there was a Haida woman in all through the environment. And so the question, or one of the questions could be, is how do you make decisions with all of these women comprising the world around you in real ways? And so that doesn't mean that we stop our activities, but what are the different considerations and how are decisions then made differently, or might they be made differently? So I think that there's all kinds of ways into that question, including, what's our definition of wealth? What's our definition of a healthy community and citizenship? So I think that change is going to take place when people understand that they matter in the decision making that affects them. Like it's not everything, but it's one of the key pieces. And so how do we do that? All of us, how do we take up that question or those questions in the work that we do, no matter wherever we're working, wherever, whether we're a kindergarten teacher, whether we're a faller, whether we're, someone who is, working on the highways, like whatever, like, so what are the ways that we can take up and challenge our own grids of intelligibility?
Thank you. The next question comes from Tamara, and it's a follow-up to my question. They write, do you find there is more attention as far as student interest by presenting these ideas in a graphic novel, or are academic essays and articles still sustainable and engaging to the intellectual mind of interest?
We need it all. We need everything. We need lots of ways, lots of resources to push our own thinking, to make sure that we're still, that that we're using our brains. Like, who was it? Bernard Shaw or somebody who said something like, "There's so little thinking in the world that I'm famous because I do it for 15 minutes a week," or something. That's not an exact quote, but we need more complicated conversations. You know, I worry when I look out there and I see major clashes happening because in our communities, we're not able to talk about health. We're not able to talk about and to disagree in ways that are constructive. We immediately go to anger and attacks, and we can do better. Like that's the way that we engage with one another is a consequence of how we think. How we talk reflects how we think. So how are we talking to one another? So I think that there's lots of room for videos, for songs, for artwork, for graphic narratives, for everything else to be able to push us into learning something new.
Yeah, trust me, I'd rather read graphic novels than a 20-page paper, but maybe that's just me. Our next question comes from Srash. I'm wondering how much law school institutions can be seen as effective places of change when they predominantly focus on and frame everything in the context of common and civil law in this place we all call Canada. I admire UVic having the JD program, but unfortunately at other law schools like mine, Osgood, it seems like Indigenous faculty and students are overburdened with getting others to recognize and prioritize Indigenous legal practice and ways of problem solving.
So there needs to be more, obviously, you know, like all of us need to continue to try and take up the TRC's calls to action in law schools and in everywhere else too in our society. You know, we're creating resources here, you know, others are creating resources, and we do a lot of professional development with judges, with you know, law professors, with law faculties, and as I mentioned, you know, there's now 4 Indigenous Law Research Units across Canada, and we support other people in the rest of the world too. So all I can say is, you know, you may not find all the opportunities that will enrich you in law school as much as you'd like, but you know, there's going to be opportunities outside of law school in your legal practice to take up, you know, additional learning, professional development, ways of working with communities, just ways of thinking and materials to draw on. So I think that, you know, it's good, just going to take a bit more time. Like we're only just our first cohort in the Indigenous Law degree program, with where students get the 2 law degrees. Our first cohort is graduating this next year. So they're going to be out there in legal practice. And so we've been spending a lot of time talking to law firms and everybody else to say, don't force them into this little common law box, because they can do way more than that. Like, look at what they're going to be able to do insofar as legal perspectives, insofar as legal thinking, and so on. And already we get amazing feedback from all the employers who've hired them over summer jobs and so on, that the students have so much more in the way of capabilities. They're not perfect, right? They got a long way to go to, because when you graduate from law school, it's just step 1. So, but to try and create room for them, and all of this work, we all have to keep doing it for a while longer.
Thank you. Our next question comes from Estella. When you talk about democratizing law and how there has to be a way in for people, how do you counter issues of fundamentalism and gatekeeping in communities, i.e. valuing and upholding certain types of knowledge holders, elders, leaders, etc., within the communities, and not creating space for others? Do you have any tips on doing this work inclusively?
Hi, Estella. You know, this is an ongoing challenge. It's a real challenge for all of us trying to do this work. Fundamentalism is one of those brain deadening kind of forces that has an appeal if people are looking for answers, if they don't know how to get other answers, right? So it's also a way to maintain power in that it's a way to not have people do the thinking or ask the hard questions. It's a way to deflect all of that. So we try with lots of different tactics. Part of the work that we do with Indigenous human rights is about looking at fairness and inclusion and dignity, and it's Indigenous women who are wanting to do that work, right, in communities. And some of them are saying, we need to do our own workshops because we just need that space to be able to work together, or we just need a women's project. Okay, so we get different kinds of requests, and because of power dynamics, law, like this already, like law is always being constituted by and constituting the power dynamics around it. It's never separate from those, right? Because it's a part of governance, it's a part of the economies, it's a part of everything else. And so when there are unhealthy dynamics, that's, then you have the failure of law. We always have its promise, but we also have to understand its context and then look at the potential failures. And I think about, apartheid was a lawful process from some perspectives. Like we can look at terrible things in the world that were done from lawful perspectives. My most common strategy I use the most is when I'm told either to limit my role or to limit what I say or to any other thing like that, is I say, well, I have a different interpretation, right? There's a different way of understanding this. And, sometimes that's helpful. I've also been starting to look at other ways that we can provide, it sounds trite, but like wellness support, fundamental wellness support for, in particular, Indigenous women who are in those situations. And it's a part, there's work on this that's international insofar as, extreme violence against women. So I think that there's much more to do on this topic, and I think it's pretty relentless. I think that as long as we have ways where power can be unchallenged in the institutions that we create, it's going to be an ongoing problem.
Thank you. Our next question comes from Trevor. Thank you, Dr. Napoleon, for this talk. I'm completely new to this area, so I'm sorry if this is an obvious answer. Is there a shared view of Indigenous law among different Indigenous groups, or is there variety? If there is variety, how do different groups reconcile conflicting ideas of law?
Thank you. So it's really important to think about linguistic groups, and it's really important to think about law on a societal basis, not on a community by community. Like the Indian Act and other forces have been really successful in fragmenting Indigenous peoples into smaller geographically pinned entities. And the consequence of that has been shifting horizontal relationships, which mattered historically, to vertical relationships between small communities and the state. So there's big consequences to the reorientation of Indigenous political life through the Indian Act. And so when you're thinking about Indigenous law, there's a Gitxsan legal order. There are 7 Gitxsan communities. There's a Cree legal order, and Cree are, as you know, spread across Canada. So we can think about alliances, but so larger than communities. Insofar as conflicts, there are lots of conflicts between groups and communities. Some of them are concerned land, but there's also situations where colonization has sped up our own international processes. And we have more than one legal order in a same geographic space. And so the work that I've been doing is to look at how, like, people, for the most part, with varying degrees of success, people are managing that through families. So up in the Northeast, for instance, there's Cree and Gitanyow law up in that part of the world, not the only ones, but the main ones. And so what are the Cree and Gitanyow legal questions? And so looking at oral histories and then looking at drawing from both in order to solve a problem. Like that's one approach that I've used in those situations. But, it's the people have the capacity to reason through these kinds of situations. So the first step, as I said earlier, there is no intact legal order ready to spring to life. The work is about rebuilding. The work is about, doing that rebuilding in a way that the law belongs to everybody and they are able to disagree with each other with it. So there's lots more work to do and no easy answers. And it's going to take time too.
Thank you. Our last question, and then after which I'll hand it back over to Justice. The last question is, considering the impacts of colonialism on our communities, were there whole Indigenous communities who view Indigenous culture as inferior? How do you suppose we can revitalize our traditional legal orders within our communities?
Well, we're working across Canada, and we don't, and people come to us with questions about their law, and we work with them for up to 2 years and sometimes much longer, because one project will usually turn into another project. So that work of engaging with oral histories as a serious source of ways of thinking and ways of recording information from the past for the present, like all of it, like taking Indigenous law seriously is a first step. And what we see is when that happens, when we go through workshops and so on with communities, people sometimes say things like, I never thought that our culture mattered. I never thought that there was anything in those stories. I thought that the stories were just for kids. And some of that is because of the way that they're talked about, like as if they're parables, as if they're not records of law, as if they're not records that generations and generations and generations have maintained and passed down for good reasons. The simplification of the way the narratives are talked about really has undermined our laws to ourselves. And so it's reclaiming that through the rebuilding, and it's learning together. And law can be an inclusive way to do that. Like lots of our peoples have been disconnected from their own communities through no fault of their own. Engaging people in that kind of processes, it's often we find a way of bringing people in. It doesn't matter what they know or don't know, right? It's everybody has to learn together.
Thank you. Seeing that it's 12:59, as I said, pretty sure that was our last question.